Hi everyone, thank you for joining. We're just going to give it a few minutes for people to join and then we'll kick it off. We'll just give it one more minute. Great, we might kick off and people can join as they come. So hello everyone, thank you for joining. My name is Georgina Johnston and I'm the Policy Officer at the Centre for Environmental Justice at Community Law Mediation. So for those of you who don't know, community law mediation works to empower people by providing free legal information and advice in the areas of employment, housing, homelessness, social welfare, child and environmental law. We also provide free mediation and conflict coaching as well as education services. Over the years, community law mediation, or CLM, has adapted and expanded its services in response to changing needs. In 2021, CLM established a Centre for Environmental Justice in acknowledgement of the fact that climate change and other environmental harms were contributing factors to many of the issues presenting at our clinics. So the centre was established to ensure that no person or community is disproportionately impacted by climate change and other environmental harms, and that environmental measures and climate action protects and builds equality and social justice. As the webinar goes on, I'll send some information about our free legal advice clinics into the chat, as well as a link to sign up to our newsletter to keep up to date with our work. So one of the key pillars of the centre's work is improving access to justice, to environmental justice, for underserved communities. So this webinar today will cover the cost of access to environmental justice in Ireland. In May, the government introduced regulations that set out a scale of fees for environmental judicial reviews. This is a cap on recoverable legal costs in successful environmental cases, which may leave applicants with a huge balance to pay despite being vindicated by the courts. These regulations have significant implications for the determination of who can afford to access the courts to protect the environment and their environmental rights. According to the Department of Climate, Energy and the Environment, 98% of the more than 1,400 consultation responses did not support the introduction of the scale of fees because of its potential detrimental impact on fundamental legal safeguards. Today we are going to hear from Attracta Uí Bhroin, Carol Day and Justine Schönfeld-Quinn about the scale of fees and the impact it could have. So we will begin with Attracta's presentation. Attracta Uí Bhroin is Manager and Law Officer of Environmental Law Ireland, an initiative concerned with the protection of the environment through improved transposition, implementation and development in the law. It is hosted by Antashka. Attracta engages at the national EU, UN, ECE and at times UN level. Attracta works across sectors but has a particular focus on environmental democracy and the intersection with human rights. She also works on the intersection of trade with sustainability and human rights concerns. Attracta served as Vice President of the European Environmental Bureau for multiple terms and is an EEB board member. Thank you so much for joining us, Attracta. I'll let you share your screen and you can kick us off.
Thanks very much, Georgina. I just hope I'll be able to do it now. We had it all working beautifully earlier. Can you see that?
Not yet. Take a minute to kick in.
Sorry about this, folks.
Something's happening there now. Yeah.
Can you see that?
Yeah, that's perfect. Thanks, Attracta.
Okay, now my apologies, I've lost all of you, so you'll need to shout at me if you need me to stop or do something. But first of all, thank you very much, Georgina, and indeed all at Community Law and Mediation for this opportunity to just engage with you and a wider set of stakeholders in relation to what's been happening. You've said everything that I needed to say, so I don't really feel that I need to say much more. But I will go through what I've been asked to touch on today, which is basically the extent to which effectively the scales of justice really are fundamentally under threat by what's happening, not just in relation to the scale of fees and the cap that you spoke about in your introductory remarks, but indeed about wider developments in the area of access to justice. So just to bring people back, for those who might be a little bit less familiar, to understand effectively what is being taken from us in relation to the current rules on judicial review and what has now been introduced, and just stepping through that in a little bit more detail. Looking at a very high level in the legal concerns, just given the time constraints today, and just talking then about the wider context and the consequences, which I know Justine will be looking at a little bit later also. Basically, just putting Irish legal costs in context, the normal rule, as most of us will be aware of, is a thing called costs follow the event or loser pays. So the real risk for anybody going to court in Ireland has traditionally been that if they lose, they not only have to pay their own legal fees, but they could be exposed to the legal fees of the body that they have challenged, and indeed any notice party, anybody who's had an interest maybe in, for example, in the development that was at stake in the decision that was being challenged. And in the context of the scale of fees and litigation costs in Ireland, that was not so much chilling as freezing in an Irish context, because the costs could run into tens of thousands of euro and indeed hundreds of thousands. And Ireland, particularly given the exit by the UK from the European Union, is probably the highest cost regime within the EU. And those costs are very high for multiple complex reasons. And former Chief Justice Frank Clark has really highlighted these in terms of systemic issues and structural issues in the way litigation runs and the way we fund our courts. And I think it's really important not to lose sight of that, because none of these factors have really been changed. There has been no substantial reforms that really make meaningful differences to the burden of cost that arises. And as the former Chief Justice highlighted, that means that effectively the costs get transferred to the parties in the proceeding. They carry the burden for assisting the judges, etc., through the cases. And that's a really important context, which we'll come back to. So those prohibitive costs were a real problem for Ireland when it wanted, just before its last EU presidency, interestingly, to ratify the Aarhus Convention and to address wider EU law obligations in respect of making sure that there was effective access to judicial remedies to uphold things like EU law rights. So there was a particular change made to the standard cost rules, and that each side had to bear its own costs. But very importantly, if you were successful, you could be awarded costs if you win. Now, this was not an absolute guarantee of costs, and we've seen that sort of particularly evolve in the last couple of years in particular. But it did facilitate basically a shift in relation to accessibility of access to justice and access to the courts. And that award that you can win is generally relied on by people of ordinary means, just people like yourselves, myself, and ENGOs in particular, to pay their lawyers. So if your case is considered to have good merit, lawyers are more inclined to take the case because they can rely on that award in order to be paid. And that's basically given rise to what's commonly referred to as a no-fault, no-fee model, where those costs are relied upon. But those costs, basically, it's not just a prescription to write out, however many zeros that you want, or a free charter, basically, to charge exorbitantly. Those costs are not arbitrary. They are independently evaluated by a legal costs adjudicator, and they can and have to be detailed and evidenced in terms of their justification. The other advantage, I suppose, of the case, and it's a little bit of a sword that cuts both ways, but is that if a lawyer feels that the case hasn't a chance of succeeding, they're unlikely to take it. And that does have an advantage for the state and for state respondents and notice parties in relation to, unmeritorious or poor quality cases basically not being proceeding. Now, what happened was this allowed for a normalisation of flow of access to justice, not a floodgate, despite what certain members of the Oireachtas said at the time when it was being introduced. And I think it's important to realise that not many lawyers are actually willing to operate on this basis, particularly those who are capable of taking on the state and big developer interest in this complex area of law. But it did actually lead to a number of very significant environmental cases. And I think, as we all know, there was a particular spike around really problematic legislation that was introduced to facilitate strategic housing, which of course the government ended up having to repeal because it was so problematic, compounded by issues which were unfortunately prevalent within the then on board Pleanála at the time. But basically, so those rules were effectively created to remove a barrier, whereas these new rules and costs have been erected to create a barrier. And they're in the Planning and Development Act 2024, Part 9, Chapter 2, but that has just been recently commenced, and as Georgina highlighted, the regulations to introduce the provisions which will cap the award, put a ceiling on the award that you can win if you are successful. And those fee rates are being set by regulations with different tiers in relation to complexities of cases, but that's only determined at the end of the case. So the problem is that cap level may fall short of the actual legal bill that you will need to foot in order to be able to mount a realistic challenge, and in order for lawyers to be able to continue to operate at competitive rates. The courts will have very limited discretion to vary, having a very high threshold, and also these rates can be changed at the flick of a ministerial pen, or left to stagnate, as I'm sure Carol will be highlighting, as has been the case in the past. So those were the provisions in law, but of course we wanted to wait to see what actually happened and what was introduced. And in the last couple of weeks now, that these regulations with these new rates have been introduced in the statutory instrument 200 of 2026. And basically, the bottom line is, in every sense of the word, that the winner pays now. And you have to mind the gap. For those of us who are used to the tube or travelling in the UK might remember that. But the mind the gap is a really significant issue now, because even if you're like this gentleman on the right-hand side of the screen and you've just been vindicated before the courts and having won, you could still end up effectively being penalised for having taken that case by having a very substantial legal cost bill. And particularly in the context of the rates that have been set, they leave quite the gap. In the context of even the consultation that was had on what was proposed before, the Bar Council of Ireland indicated that the rates were between 23 and 38% of established reasonable costs. That's one hell of a gap. So the bottom line is, in every sense of the word, successful applicants will be effectively penalised for upholding the law. That sounds good to you, then we disagree. And I think it's really important to realise that even though these are in the planning acts, and some people sort of roll over and yawn when they hear planning, but this is intended to be rolled out across all environmental JR. And as I mentioned earlier, the cost drivers, which Mr. Justice Frank Clark spoke about, have not been removed from the system. There's been no properly informed reforms, no proper transition to this new system, and no evidence justification, and no real transparency around how these rates have been come up with and justified, either in the context of the costs associated and the indicative costs that were even highlighted in the consultation that we had to do over Christmas and New Year, or indeed in terms of their transparency, in terms of the requirements of the 2024 Act itself. As Justina mentioned, there was a significant consultation, and 98% of those were opposed to the cap. And I think the real risk that we really need to be fearful of is not just the big bills, because the reality is people just won't be able to foot them. And ENGOs simply just won't be able to raise the funds, is that it will precipitate a flight from the practice area. So lawyers won't go hungry. Lawyers will just move into other areas of practice. And this undermines the application of justice in environmental cases, because it's not a case of any lawyer will do. Give me a lawyer, open the golden pages. You actually need extraordinary expertise when taking on these cases, given the complexities of the fact matrix, the complexities of the law, and the calibre of the resources that are there on the state side and developer interest side. I think that's the other important point I really want to highlight, is just the unfairness of what's proposed, because it's a bit like me saying to you, Georgina, let's play a game of football, but I'm effectively going to tell you who and what calibre of players that you can actually put on the pitch and how long they can stay. But by the way, I'm going to be choosing my team from the Premier League, and I may change the rules at half time. That's effectively the situation that we're in now, is a completely unequal playing field. In terms of legal issues, and for obvious reasons, I'm not going to get into this in too much detail, but the Aarhus Convention, Article 9.4, is very, very clear in relation to that costs need to be not prohibitively expensive. But I think in talking about these rules and the issues that they bring to bear, is we should not be just overly focused on Aarhus, even though, like I think most people know, I'd die in a ditch for it. But there is a much more complex, wider architecture of access to justice, particularly given our membership of the EU, which reaches to the treaties, the EU Charter of Fundamental Rights, and a whole range of other instruments. And the Court of Justice has not been shy in highlighting that really complex architecture. But I would just draw your attention to the fact that it's not just access to justice, or not prohibitively expensive, is one of the key characteristics that Aarhus requires, because it doesn't sort of say that thou shalt be able to challenge this, that, and the other. It actually requires specific characteristics to be in place in order for that to be a meaningful right. So you have to have adequate and effective remedies, including injunctive relief. You have to have fairness, equitable, and they have to be timely, as well as not prohibitively expensive. And each one of those characteristics is important. And I'm just very conscious of time. So I'm going to try and rattle through this, but I would just say each one of those characteristics is now under fire in Ireland. And I think we need to be really conscious of that it is not just the scale of fees, it is not just the Planning and Development Act, Chapter 2 on costs. It's Chapter 1. It's also a whole range of other legislation. I'm just putting that slide just up there, just by way of, even in an older case, and there's even more recent ones which are even more powerful, LZ2 basically just highlighted elements of that architecture, from the treaties of the European Union, the Charter, the importance of the evaluation of the proportionality of the response and the impingement of rights under Article 51. There is a lot of boxes that need to be ticked that have not been ticked in respect of these rules. But it works fine in the UK, is what we heard all along, and we're still hearing that even at the conference that we had in the King's Inns last week. And no, it doesn't, but we will hear more from that in Carol. But for my own part, I can testify, based on experience in litigating in the UK, how difficult it is, particularly for smaller NGOs and smaller organisations. And even if it did work well in the UK, I would like to make a very clear point that there are significant structural and legal differences which make these proposals particularly unsuited to Ireland. And we have to be mindful of the way the Court of Justice looks at things in a very localised context, in terms of considering how it impacts on the broad obligation of wide access to justice in respect of issues around standing, scope of review, costs, all of these different factors. So Ireland is not the UK. Our ENGOs, our communities, our population, the way our legal practices are structured, there's a whole range of different factors which make what might work for some NGOs in the UK, makes it absolutely, unsuitable for us. But I will leave Carol to expand on that. So I'm just going to finish by just saying that it's really bad our house bingo with changes in multiple instruments and proposals right across the board for standing, scope of review, fairness and equity proceedings, adequacies of remedies, expense, combined with an unprecedentedly negative narrative, which has been very chilling and intimidating, not just for individuals and groups, but indeed for their lawyers. We're looking at something that has not been justified by data or evidence. It's not proportionate and without adequate safeguards. And I'm saying those things in very charged terms with reference to judgments of the EU Court of Justice, for example, in Puskar, that laid out very clearly where rights are being impinged, how it is really important that that is done in a proportional way with appropriate safeguards. And we're already seeing further chilling associated with these changes, but that's probably for another day. I would just highlight, the problems and the implications. It's not just in relation to the impact on access to justice. That was a comment just there at the top of the page from Mr. Justice Brian Murray in the Supreme Court case in Heather Hill, which we thought and had hoped had put to bed one final last issue of clarification around what were the original cost rules that were introduced to comply with our House. And in just working through and settling those out and figuring out what was meant in that legislation around not prohibitively expensive, there was at least 35 reserved judgments of the High Court, 4 decisions of the Court of Appeal, 3 references to the Court of Justice of the European Union, and then that judgment of the Supreme Court so far. I believe that list is actually conservatively estimated. But now we're looking at a whole plethora of key factors basically being changed. And you can just start to do the maths and just consider the implications for the satellite litigation that is going to be spawned out of this, and the implications that will have on the resources within the court, the creation of uncertainty, and the delays to investment, basically, particularly in the areas of housing and critical infrastructure, and indeed also infrastructure required for our energy transition. So those issues of satellite litigation are being compounded by the issues with the quality of legislation. And I could wax lyrical about what's happening in our Oireachtas today and yesterday in relation to how legislation is being rushed through, really complex, significant legislation being rushed through, and that is likely to lead to flawed decisions. And then those flawed decisions will be compounded with the further quagmire of satellite litigation around rules around access to justice. There's a whole plethora of bills and proposals out there and general schemes that are putting our whole scheme of environmental justice under fire. And basically, in particular, I would highlight the Civil Reform Bill. I spoke in Cork, and Carol will remember this. It's like it's legislating in a bubble, in a vacuum. It's as if all of these things that I've put up on the screen don't exist. It's quite an extraordinary piece of legislation where you think about looking at Part 3 on judicial review in the context of environmental legislation. So last words, mind the gap, and thank you very much. And there's some slides at the end which just highlight some of the really important cases that have been taken, which the future of such cases is now in peril. And that's why pushing back on this is absolutely critical. Thanks very much.
Thank you so much, Attracta. It was really great to hear that the wider context and the gap created by the regulations and the unfairness of this. Thank you for providing that context. We'll move on to Carol, and I'm just going to share Carol's presentation. Hopefully you can all see that. And I'll just introduce Carol. So thank you so much for joining us today, Carol. Carol has worked in the environmental sector for over 35 years. She trained as a solicitor at Leigh Day and rejoined the firm to run the Environmental Litigation Service in 2013. Carol's career started in the voluntary sector with grassroots experience at the Warwickshire and Surrey Wildlife Trust, and over 20 years on policy and advocacy with WWF UK. She now works part-time for Leigh Day, focusing on cases concerning biodiversity, planning and climate change, and is also contracted by the RSPB to work on the UK's implementation of the Irish Convention. So thank you so much for joining us today, Carol. And you can tell me as you want me to move along with the slides.
Thank you very much, Georgina, and thank you to CLM also for inviting me to speak at this event. It's clear there's real root and branch reform happening on costs and JR generally in Ireland, so I'm very pleased to be able to contribute, and apologies for being a dinosaur and having to ask you to move my slides on, but thank you for doing that as well. So we can go to the first slide, please. I don't need to say too much about the background. That's all being covered very ably by Georgina and by Attracta. So what I'm going to do today is just give a really brief overview of the Aarhus cost regime as it operates in the UK. And then I'm going to focus down on the particular elements of that the Irish government is replicating. So that's the reciprocal cap that we have. So we'll look a little bit at that, at how it works and what the limitations of that are. And then I'll finish with some concluding remarks. So if you could go to the next slide, Georgina, that would be great. Thank you. Okay, so the Aarhus cost capping regime in England and Wales. I mean, what I'm going to say here, actually, it's quite an interesting parallel with the situation in Ireland in the sense that, as Attracta said, we used to have a general rule in costs. I mean, we used to joke in court, the general rule in costs is that there are no rules, but it generally is that the losing party will pay the costs of the winning party. And that means that any claimant going in to take a judicial review not only had to budget for their own legal fees and any court fees and applications that might arise, but they also need to budget for the cost of the other side should they lose in court. And we'd had a really big case that we took while I was working for WWF. It was in Scotland. It was about a proposal to build a funicular railway at the side of Cairngorm. In fact, it has been built. But we took a JR in Scotland and lost, and WWF was hit with a cost bill of over £200,000. Now, that was in the 1990s, so you can only imagine how much that would be now. And you could also imagine that absolutely terrified our trustees at the time, and they really have been very litigation averse since then. It was as a result of that we drafted a complaint that went off to the European Commission, because we were in the heady, wonderful days of being in the EU at that time. And that led to widespread infringement proceedings against the UK on the issue of costs. And also, as Attracta mentioned as well, we've had a number of different communications being submitted to the Aarhus Convention Compliance Committee on costs, including 3 in the UK. And those findings from the Aarhus Convention Compliance Committee have found that the UK was in breach of the Article 9.4 not prohibitively expensive requirements since 2009. So this is a very long-running chestnut. So as in Ireland, I noted it was 2011, in 2013 in the UK, we had bespoke cost schemes introduced into England and Wales, Northern Ireland and Scotland, and the schemes are quite different. So I won't go into all of them, but I will talk in a bit more detail about the scheme in England and Wales. So next slide, please, Georgina. Thank you. So the starting point for the scheme in the UK is that what happens is the adverse cost liability of claimants going into court is actually capped. So if you're an individual going to court, you can apply for a default cap of £5,000. So if you lose, you'll pay no more than that. Any other case, whether that's a community group or an environmental NGO, your cap is £10,000. And you apply for that default cap when you actually apply for a judicial review. And you provide with your application a schedule of your financial resources, your assets, income, liability, expenditure, and the aggregate amount of any third-party support you're either relying on or seeking to rely on. Now, the quid pro quo for having your adverse cost liability capped is that there is a reciprocal cap of £35,000 inclusive of VAT. I'll come back to that. Just a couple of other facets about the regime. It only applies to members of the public. And a very important element of it is that there is now the possibility that those default caps of £5,000 and £10,000 can be varied. This was introduced in 2017. So the claimant can, in theory, apply to have the cap reduced, or the defendant or the interested party, following a case called Bertoncini, can apply to have the default cap usually increased. And the court can approve that, or they can even remove the cap altogether, if they are satisfied that doing that wouldn't make the cost of the proceedings prohibitively expensive for the claimant. And they apply 2 tests in deciding whether that is possible. They say that the proceedings are prohibitively expensive if the likely costs, and that includes own legal costs and court fees, either firstly exceed the financial resources of the claimant, so that's a subjective limb. They look at the individual claimant and their particular financial circumstances and whether an increase in the cap would be prohibitively expensive for them. But they also look at a second objectively reasonable limb. So they look at a variety of other factors and they decide whether the cap is appropriate, having regard to things like whether the claim has reasonable prospects of success, the importance of what's at stake for the claimant and the environment, the complexity of the relevant law and procedure. So as I say, it's a two-tier test as to whether that cap can be increased or not. Next slide, please. Now, focusing really in on the reciprocal cap, because that is the element of the scheme that the Irish government has decided to lift and apply in Ireland. We mentioned that it's a £35,000 cap. That was very similar to the figure that was used in the McDade report as part of the consultation, which was a fee of just over €40,000. And they said in the report that it was relatively close to the England and Wales fee of £35,000 sterling. Now, we should just say that figure has not been adjusted for inflation since 2013. It equates to just under £48,000 now. And in England and Wales, it doesn't include VAT. That point was tested in the Heathrow judgment. Different in Northern Ireland, actually, the figure is exclusive VAT, just as a matter of aside. I think the really important point to make about that figure, it actually comes from case law, cases such as Corner House and Garner that were fought in the early 2000s. And that figure of £35,000 is not an objectively reasonable figure when you look at the current complexity of cases that firms like Leigh Day are taking. It essentially makes anything but the most basic JR too expensive to win. And I've given an example there. It's at the outer edge of the extreme, but it's by no means a complete outlier. And it's a case we took on behalf of the Northern Ireland Badger Group and an NGO called Wild Justice in Northern Ireland. And it was in relation to the proposal to introduce badger culling in Northern Ireland. It was a consultation claim. We were actually successful and we were able to claim the full £35,000 of the reciprocal cap from the other side. But the total fees that we incurred in that case were nearly £250,000. So we got the £35,000 from the other side. We were paid £45,000 under the fee arrangement we had with our client. And I'll come back to this because it's very important. And that made a total cost recovery of £80,000, but it left us with a shortfall of £163,000, which is an enormous amount of money. We'll go to the next slide, please. So the result of these sort of very large sums of winning cases is that actually lawyers end up subsidising the defendant's costs of defending claims. Now, I think one of the points I want to make here, and it touches on the point that Attracta said, is that it's a feature of the type of organisation that Leigh Day is, that we're able to bring these firms. We're a large multidisciplinary firm in London. We've got about 750,000 lawyers and staff. And environmental work is only one element of what we do. So if we operate at a loss on our environmental cases, which we often do, we are able to be cross-subsidised by other parts of the firm. So the fact that we do this work is something that it's a decision the firm makes in the interests of our clients and access to justice, in spite of the systemic problems that exist. Now, I can kind of hear the collective sobbing down the line of, it's terrible that lawyers aren't making their money, but this has real implications for people on the ground. It's not just about the lawyers, and I'll come back to that at the end. Now, in theory, our civil procedural rules are capable of complying with Article 9.4 and that not prohibitively expensive requirement, because as you remember, we can apply to have the reciprocal cap varied upwards or removed altogether. But I should say that's extremely rare. Any application to increase the caps has to be made early on in the proceedings, and it's very difficult to always tell how complicated a case is going to be at the beginning. We certainly wouldn't have known how complex the Northern Ireland Badger case was going to be when we started out. And then when you apply at the end, if you find that you have done a case, it is very complex, and you apply at the end, the application, the one where we've found, has actually been rejected because it's not found to be a significant change of circumstances justifying a later application. So I have to say it's not been our experience that we can actually, increase the cap at the end and recover our costs. Now, Attracta mentioned that really important point about fairness, which is mentioned in Article 9.4 of the Aarhus Convention. And I think it's important because it's a point that's consistently made to us by the government. And in Communication C33, the UK government, said it's important to recognise that the provision of a fair and just system of law involves treating all parties to the litigation fairly. The resources applied by public authorities in defending JR proceedings stem ultimately from the taxpayer, and it's therefore proper that the cost implications for both parties in an individual case could be taken into account. And we hear that argument about the burden on the taxpayer all of the time. But it's really important to point out that the Compliance Committee looked at this issue because it was raised in that communication, and they adjudicated on it. And they said that the point about fairness in Article 9.4 relates to what is fair for the claimant, not the defendant public body. And I've put the paragraph reference there where they actually made that very important finding. Next slide, please, Georgina. Now, in England and Wales, the impact of the reciprocal cap can be ameliorated to some extent, and it's by a combination of factors that we have operating in the UK, namely the fact that we operate under discounted conditional fee arrangements. I'll say a bit about that in a minute. The availability of crowdfunding and the wider context in which we are able to operate. So the fee arrangement we have with most of our clients is to operate under a no-win low fee. It's not a no-win no fee, it's no-win low fee, a DCFA, which means that we act for our clients on heavily discounted rates if we lose. But then the arrangement enables us to recover at commercial rates when we're successful. And that means that we are generally able to recover up to the 35,000 cap, and certainly well able to claim up to that in complex cases because the fees are so high. Now, I note that in Northern Ireland, they don't permit those kind of arrangements, so that's a kind of a difference between the schemes. And in Ireland, Attracta mentioned that no fault, no fee arrangements are possible. But a really important component on top of the DCFA is then being able to, in effect, top up the gap that Attracta was mentioning about is through the role of crowdfunding. And we very routinely our clients raise funds through platforms like Crowd Justice. They're very heavily used over here. And the reason they work quite successfully is because we have quite a lot of large established charities, often with international reach. We have a couple of clients who've got big kind of US firms, charities with US branches who are, have particularly well funded. But some of these charities, they're very, very good at fundraising. Quite a lot of them have celebrity figures associated with them. So, people like Chris Packham, who can tweet out the link to a fundraiser and they can raise funds pretty quickly. An example of that is we did a case on microplastics in sewage sludge for a very small charity called Fighting Dirty. And they had George Monbiot as one of their company directors. He wrote an article in The Guardian about the case. He put the link to the crowdfunder in the case. And that case was funded very quickly. But you can imagine that, trying to raise funds about microplastics in sewage sludge is not something which is, it's quite niche. It's not something which is going to get a lot of reach. And so the fact that we have these people who are able to amass a large degree of public concern very quickly is a really important component of making these cases work. And as I understand it, champity remains unlawful in Ireland, so I don't think that kind of crowdfunding part of the equation is something which can be run in Ireland and will cause real problems. Final slide, please, Georgina. Just a word on adjusting for complexity. As Attracta mentioned, there are different figures for different cases given in the SI. As I understand it, it's just under €40,000 for a standard case, 52 for complex cases, and 65 for very complex cases. Our costs in terms of a standard JR, we routinely quote around £40,000 to £60,000 VAT for a standard claim. So you can see that's not really going to go very far in terms of those figures. They're wholly inadequate in terms of a complex case like the Badger case. And as I understand it, and Attracta affirmed, your case, I think your costs in Ireland are even higher than they are in the UK. And as I understand it, there is little provision or no provision in the SI to vary the reciprocal cap as we have in the UK, in theory at least. So just to conclude and sort of bring the strands together, there are serious implications of replicating components of the UK regime in Ireland without being totally cognizant of what those implications are. There are ramifications for lawyers, and I say it's not just the fact that this impacts on lawyers. The really crucial point there is if lawyers can't pay their bills, they won't do the work. And if you have a firm which is just an environmental firm, they only do this work, they don't do other types of work, they're simply not going to be able to continue to operate. And all of the expertise that Attracta referred to will therefore be lost. So yes, there's implications for lawyers, but of course then there's implications then for the people that they represent, and that will create a very significant access to justice deficit, which will mean that there will be non-compliance with provisions of the Aarhus Convention and components of the PPD in EU law. Also, I've just mentioned there that I think it's likely to increase, as it has in Northern Ireland, in an increase in the number of unrepresented litigants, which I think has very serious implications for the judiciary, because I think they often require a lot of help to be able to put their case as effectively as they want to before the court. So thank you. That's all I was going to say at this point, but I look forward to any questions that we might have after we've had the next presentation. So thanks very much, and thank you for Georgina for doing the slideshow.
Thank you so much, Carol. It was really important to hear about the implications of replication and how cases have become too expensive to win over in the UK. So thank you for sharing. We're going to move on to our last speaker, which is Justine. So Justine is Senior Solicitor at the Centre for Environmental Justice at Community Law and Mediation. She works on climate and environmental cases in clinics. Before moving home to Ireland in 2024, she led a team of 6 lawyers at Client Earth Berlin working on industrial emissions, industrial and agricultural chemicals, and climate laws. Justine previously lectured in law and practiced as a barrister in Dublin. She is a graduate of Trinity College Dublin and London School of Economics and Political Science. So thank you, Justine. Would you like me to share the slides, or do you want to share them? You're on mute there, I think. Yeah.
I may give it one go just to see if it works.
Yeah.
I'm actually on a different computer than my own today. So let me see. Okay. And I think I go.
Yeah, that's perfect. If you just move to slideshow, then it should work.
Perfect. Okay. Thanks very much. So just to pick up on some comments there made by Carol, we have a deficit in access to justice in Ireland, and the reference made there to the number of unrepresented persons that featured recently in a news interview given by the president of our Court of Appeal, and she gave the figures for the number of unrepresented applicants in civil appeals, and it's really, I had to read it a few times, and I've been reading it again in the background there to understand. Incredibly, 35% of civil appeals in 2023 were brought by unrepresented applicants, and the figure has gone up to 43% last year. It's been climbing steadily every year. So just to explain what this looks like in practice is that court procedures are phenomenally complex, and those are just the procedures. That's just, can you move your case through the list? Translating your legal issue into a legal case that takes a form that a court can respond to and give you an appropriate relief is very, very difficult for someone without legal training to do. So it is a really, really serious issue that the number of people who are having to represent themselves, and I think President Costello commented that most people didn't want to be in this position. So we're already in a crisis position in Ireland. Just a little bit of background to the Centre for Environmental Justice. It's been in existence for 5 years, and it was set up in recognition that environmental issues affect people differently based on their circumstances, so that underserved communities are particularly facing environmental issues and are unable to access the resources that they need to actually get help, whether it's from the state from the legal profession and to be able to resolve the issues that they deal with. And we have seen just a great need for advice. People coming into our clinics. We have a free information service provided by solicitors and barristers on a volunteer basis and also in-house. This runs really, I suppose, an appointment would be within a week or 2 weeks. It's very simple to make an appointment. You just call or book through the website. And we see issues coming in from around the country. And some of the issues are things like sewage coming into someone's home. And people are dealing with problems of this nature and not necessarily having any easy way to resolve them. And you'd be surprised at the complexity of even fairly local issues like this from a legal perspective. So the centre was set up in recognition of this issue. And one of the problems in Ireland that affect a great many people is air pollution, for example. And 1,300 people losing their lives every year, quite a lot of morbidity associated with air pollution. And it's very, very difficult to find information, to find a way of resolving the issue. Air pollution itself is linked to another problem, which is climate. So homes that are poorly insulated are those where people are having to resort to using polluting fuels to heat perhaps a single room in winter. So this inequality across society is affecting people on many, many different levels. And other issues that we have seen have included people facing the image that you see there, the illegal landfill in Darndale, which is not very far from community law and mediation. This built up over many years. It was 40,000 tons of industrial waste. It was said to have asbestos. It had medical waste. It built over a very, very long period. And the local resident mentioned there, she took over many years an effort to go into local authorities and to speak to them and say, this is the problem. Can you do something about it? And it essentially came forward, put herself in the position of being a campaigner and a voice to try and change this, and still had to, for many years, wake up every day and go into her front garden and see this enormous amount of waste, really just a short distance from her home, from her front door, on which there were frequent fires and there were burnt out cars around this. So there was a problem of air pollution associated with it as well. So these kinds of local environmental issues, people have to action them themselves. And in order to have the resources to take on, for example, a case concerning illegal dumping or concerning any other local environmental issue, the first thing that someone needs is they need access to a lawyer to be able to convert the problem that they see into a legal case that can be heard by a court. And as a very small community centre providing advice to a lot of people around the country, the resource that we have access to is to contact barristers and ask them, somebody's come in with this kind of problem or that kind of problem, say water pollution, can you give us advice? Can you tell us, is there a case here under X or Y piece of legislation? And the barristers are providing the advice pro bono. And if there's a meritorious case, we may instruct them to bring the proceedings. And at the end of those proceedings, they will be able to recover their costs. Now, under the new cost capping approach, they will not be paid the same as their opponents for doing the same work. So their costs will be capped. And if they're representing someone who doesn't have means, the shortfall won't be made up. So we see over time more and more people moving away from this area of practice and saying, you know, I want to help, but I can't. I don't have the means to do that. So these are the kinds of issues that people will have to face without really having access to that support or those resources. Just to contextualize it, obviously within the EU legal framework, there's a great deal of recognition of the importance of access to justice, and national rules that inhibit access to justice have been found to breach European Union law in a number of cases. It's inevitable that this regime will similarly be challenged. I think Advocate General Sharpston has been one of the most eloquent people on the subject of access to justice, and she's often, I think, sometimes quotes have been put together from a collection of statements that she's made, but very simply that the natural environment, well, it matters to all of us. It can't take action on its own behalf. It depends upon individuals to do so and NGOs to do so. In Ireland, the model that we have is very reliant on pro bono advice and pro bono representation. And that's true for NGOs, and that's true for individuals. This model is very much threatened by any change to a scale of fee or any cost capping. We're in a very different context than the United Kingdom, where you have really a completely different philanthropic environment. You have a different set of legal rules. You have very different structures. Crowdfunding doesn't exist here. So there is only effectively pro bono support. And that pro bono support depends upon the willingness of barristers to go into this area of practice and to stay in it. And for those who are at the very top levels, to be willing to take on applicant work, notwithstanding the resulting unfairness in this context, where they won't recover the same amount in a successful case as their opponents. And there is no cap on the costs that the state can pay if they are the respondent. Interests that are economically advantaged will be able to afford any manner of advice. And this is simply creating a profound inequality of arms that is worsening over time and leading to the problem of more and more unrepresented people in the courts, who, I think, as Carol Day adverted to, they have to be guided by the courts through the procedures and by the court offices. And even when they have strong cases, they may not have successfully translated them into a legal action that will lead to the outcome that they seek and that they may well deserve. And this is a problem for access to justice in the environment and access to justice in general. So the state does enforce environmental law, and there is a huge effort nationwide undertaken by local councils, by the EPA. Notwithstanding this effort, we have profound difficulties in, for example, water pollution that have proved intractable, that don't appear to be getting better over many, many years. And the environmental laws that we have, the structures that exist, they're there not just for, not just with the expectation that the state will uphold environmental law or the state will enforce environmental law and investigate and act on complaints, but actually structurally depend upon individuals and NGOs to act to uphold environmental law as well, and to take on those risks and to bring those very difficult cases. And this is a structural feature of the system. It is intended to work that essentially decentralized enforcement would be possible also. And the legislation contains various provisions. Environmental legislation has a number of different opportunities for individuals and groups to go into the court and get an order to stop sewage pollution going into the local river, to bring a planning enforcement problem to the attention of the courts. And the state is depending upon this kind of action in part, in addition to its own work on enforcement, to try and achieve a high level of environmental protection for all of us. So why it matters for the environment, it's not just the cost to the individual, the risk of perhaps winning your case and still finding that you face a bill. The existence of a meaningful legal risk is a deterrent that helps to ensure compliance with environmental standards more generally. So interests are being advised, large economic actors, well, you comply with this and this, and it's very important that you do so. That threat has to be a credible threat. It has to be real. And in addition to that, litigation is there to ensure that the state upholds its own promises. So if the state has committed itself through its laws to do a certain set of actions, that there is a means in place to make sure that the state upholds its own laws as well. And litigation is a very important tool to ensure that that happens. So just to explain one of the other areas that we work in, which is climate litigation, community law and mediation has taken a case in its own name for the first time in its history. And it's taken a case, a climate case concerning Climate Action Plan 2024. It's a fundamental rights case, and it is an intergenerational equity case. So it leverages the Grand Chamber judgment of the European Court of Human Rights in Clima Signorinum, which is a case brought by elderly Swiss women who talked about the impact that climate change was having on them and in their lives and on their health. And it's a very groundbreaking case because it's for the first time a case where the European Court of Human Rights allowed an organization to act on behalf of its members in a representative capacity, even in circumstances where the members didn't individually have standing. So legal standing is basically the rule that you need to fulfill a set of criteria in order to actually have the capacity to take a case. And currently in Friends of the Irish Environment and Government of Ireland, Climate Case Ireland, it was not possible for a company limited by guarantee in that case, which Friends of the Irish Environment is, to invoke fundamental rights. And Clima Signorinum suggests that associations can bring representative actions. So community law and mediation has sought to bring a climate case in recognition of the fact that climate change affects everyone, but the disproportionate burden of climate change will in the near term fall upon underserved communities, already economically disadvantaged individuals, homeless people, and the youth, and to be able to act on their behalf, to really bring into the conversation interests that are otherwise not represented fully in the climate space. And we see that in the measures that the state takes, for example, with regard to climate change, in terms of addressing home heating, insulation, that a lot of the grants available are available to people who already have resources, who are able to put up their own capital at first instance to avail of the grants. So there is inequality in our response to climate change, and there are fundamental rights implications with climate change itself. There are 3 other applicants in the case: a grandfather, a child, and a youth climate activist. For us as an organization to bring a case means being able to also leverage access to top senior counsel, to independent experts, and to people who are really giving of their time with no expectation of payment in the near term. So the ability of individuals and NGOs to take action before the courts is highly dependent on this, us ourselves, no full, no fee arrangement. And changes to that have a potential to chill and discourage others from bringing similar cases, and will tend towards environmental harms increasingly going unaddressed. The state being able to not, for example, fulfill the mandate it committed to with its climate legislation, and simply without consequence. So I want to thank you very much for your time, and just leave, I'm conscious of the time here, leave it open for anyone to ask questions if they wish. Thank you very much.
Thank you so much, Justine. I think it's really important to add context to the potential impact of the scale of fees on our work. And I really like that quote from Advocate General Sharpston, which I think goes to the heart of why access to justice is so important for enforcement. So thank you for sharing. We now have time for some questions. If anyone wants to use the Q&A box to type in if they have anything they'd like to ask our panelists. I think there was a comment. The comment says, we need more policy to support the implementation of the law. The policy we do have is weak and wishy-washy. NPF, like that of Scotland, would be a good example of policy ensuring laws consistently interpreted and implemented. Clear policy would also help people who challenge schemes. I don't know if anyone of the panelists want to come in on that, the importance of policy for implementation. Attracta?
I would agree in principle with the comment, absolutely, but I think we just need to be conscious of the really hostile policy environment in which we're operating in. Just look at the news headlines and the comments from numerous members of the government over, really particularly, I suppose, from June, July of last year. They were just quite extraordinarily aggressive and hostile towards access to justice. Look what's happening in the Oireachtas at the moment in relation to effectively trampling over Oireachtas scrutiny, you know, core provisions in our constitution in relation to how our laws are made and the role of the Oireachtas in that, and in principle just being trampled on. And I think it would be a bit like, you know, throwing a chicken into a fox's den or a wolf's den to sort of open up a book of policy guidance in relation to these matters at the moment, because we do have laws. We are members of the European Union. We've signed up. We get the benefits. We need to sort of fess up to the obligations. We've signed up into international conventions, such as the Aarhus Convention, and we like to trot out our record on human rights, our respect for civil society in the context of our programme for the Irish presidency of the EU. But actions speak louder than words, and the reality is that the direction of travel is really hostile at home. But it's not just hostile at home, it's really, really hostile at EU level. And today I'm sitting here in the UN in Geneva, where we're experiencing an absolute onslaught of an attack on the Aarhus Convention, like the heart of environmental democracy. And that's just following on from a meeting which Carol and I would have attended last November, of the meeting of the parties. So it's equivalent to the conference of the parties for the climate, UNFCCC. So we saw really, really serious efforts to undermine the mechanisms for compliance with the convention, and indeed indications of even going further than that are now emerging. So the policy context is extremely hostile, and I think it's incumbent upon us as citizens, and I'm speaking very much in a personal capacity here, but as members of the electorate, to make sure that our politicians actually hear how problematic we see what is going on, and to really reach out and put pressure on the government, because at the end of the day, it's the one with the pen at the moment. And if they don't hear, and if we're just apathetic, or if we're just so despondent over this, the policy slide will continue, and with that, the legislative slide.
Thank you, Attracta. Just wondering if any of the other panelists want to come in on that question on policy.
I mean, yeah, if it's, I mean, just to follow up on what Attracta's saying, I think it is a really worrying time. I think we were very shocked by what happened in Geneva last November at the meeting of the parties. In retrospect, I'm not sure we probably should have been quite as shocked from the UK side. We'd had a number of different sort of warning signs leading up to that. I still find it absolutely astonishing that the Prime Minister published an article in his own name in the Daily Mail last year, where he was talking about people who brought environmental cases as eco-zealots, as builder blockers, as people who were taking these cases selfishly to prevent infrastructure development in the UK. You know, aside from the fact these people are taking these cases in the public interest to protect the environment, but there were personalised attacks. He actually named people in that article, and I still find it astonishing that he was prepared to do that. And that then, I think, triggered a variety of different things in the UK in terms of, you know, right-wing policy tanks briefing quite heavily on the convention, leading up to what happened at the Aarhus MOP, and then also, as Attracta says is still continuing now. And that is, I think that kind of negative narrative is being spearheaded from the UK, but I don't think it's by the UK on their own by any means.
We've been up to the EU, as like we said.
It's happening across the EU, and there is a sort of a fundamental kind of, I think, pushback on the environmental democracy space in terms of any rights, whether that's being able to take cases to court, whether that's actually being able to peacefully protest, whether it's to be able to participate in decision making. You know, we've seen all sorts of crackdowns in the UK in terms of the planning system as well, and moving away from the environmental assessment regime, which I know is happening more widely in Europe as well. So I think it's a really worrying space at the moment, and I think we really need to be working hard to identify who our allies are and to how we can push back on that in terms of what's happening with policy. So yeah, just to echo the thoughts that Attracta has made, I do share those concerns.
Thank you, Carol. We have two more questions. So the next one is, do you see any potential challenges being taken on the constitutionality of these changes?
I suppose constitutionality is one possibility, but there are other avenues, I think, particularly in terms of EU law compliance, where there's a strong case law on access to justice. And there are different routes, and unfortunately, those routes still do exist. For Ireland, for example, you know, commission complaints, there are other processes that can be used. And I think really where you have something that is going to have such a detrimental and systemic effect on access to justice, inevitably somebody will find a way to action it. It's very short-sighted to roll back or change the law in this way without adequate assessment. And I think really the full weight of all the policy submissions against this change bear witness to how negatively it's perceived and how negative the effect is likely to be. And I think it'll be important to watch the courts statistically to look at the data and see what happens in the coming, in the next year really, and to see, is there a drop off in the number of cases being brought? Do we see further increase in the number of unrepresented applicants before the courts? And I think that we probably will. It does seem to be an increasing trend, and it's very worrying development because it's not just people acting without a lawyer in that environment are really in a vulnerable position, and there is a risk of cost awards against them. And as has been mentioned already, the extent of legal costs in Ireland are so high that you'll see people potentially having a liability from having tried to uphold their environmental rights for very significant sums of money, and having gone into that situation without proper advice or proper information. It's very, very concerning.
I would just add, I'm not going to comment on the taking of litigation because that's not my role. But what I would say is that what I would agree with Justine in relation to watching the data and seeing the impact. We just need to remember the world we're in. We don't have the time to lose, you know, with bad decisions and flawed decisions being taken in relation to what is necessary for our climate transition. We just cannot afford that window. We are in a critical window for the future of life on Earth. And any delay is deeply problematic. You know, any delay is deeply problematic. And in the context of the implications of these changes, I think that's one of the biggest concerns I have, is that they're potentially going to hurt good and bad projects, and they are non-discriminate. So I think that is very fundamentally problematic, and I think it is a case of just watching very carefully. Sorry, excuse me.
Just Georgina, if I could come in there as well, just to make an additional point. I think, I mean, I'm not aware of any litigation that's happening. I'd be really interested in that, and you know, I think it'd be great if it did happen. Just to mention that we did. There was a case when the UK government sought to change the cost rules in 2017. We took a case to challenge that. It was RSPB client Earth and Friends of the Earth, and we were successful in that. And obviously, I suppose the sort of irony would be if anybody does take a case and they're successful, they might actually be penalised by the new process and actually winning the case they've bought. But that's an aside. The point I wanted to make is about the data. I think collecting the data is really, really important. The Ministry of Justice over here in the UK has now refusing to collect data on environmental claims. They haven't collected anything for the last couple of years. It makes it very difficult to know how many cases there are, how they're performing. All those kind of bread and butter figures have been really important to us in terms of responding to government consultations about access to justice. And the fact that they're now not doing that means that we're operating in a complete vacuum as to the impact these policy changes are having. So, you know, I think it was brilliant when Justine mentioned it was a terrible figure, that figure of, you know, 35% going up to 43% of litigants in persons. But the fact you've got that data is really important. So even though I get it, do something now, Attracta's totally right, but do keep collecting the data, because in the long term, it's really important to have those figures. Thank you.
Thank you, Carol. The last question there is, would the provision of a substantive right to a healthy environment be impactful in this space? Can the panel comment on any progress on the same in Ireland? I believe it was a recommendation of the Biodiversity Citizens Assembly, but perhaps not progressed by current government. So just before I hand over to the panel on that question, last year, Community Law Mediation published a report on constitutionalising environmental rights. So I will share that into the chat. It's a great read, and it touches on a lot of that question. But I will hand over to the panelists as well, and maybe Justine can come in on some of the findings from the report. Attracta, if you want to, come in there.
Yeah, sorry, I know you want to give the floor to Justine, but I would just say, look, we actually have very well worked out laws with really good jurisprudence behind them, and I think we should not lose sight of seeking to enforce and implement them, and to uphold them and to defend them. I think the problem with the right to, you know, in the Constitution is it's what needs to flow and what needs to be established consequent on that, and what will need to be worked up, and the time and effort that it will take. And again, going back to foxes guarding chickens and those types of analogies, giving the current, and I'm speaking in a personal capacity, but I would also say very much in a professional capacity, based on experience of looking at the last government and this government, it'll be like, you know, the fox guarding the chickens, giving them a constitutional amendment and, you know, framing something in a way which would be helpful. And we know that indeed across the House, there was, and across different parties, there are different views and different perspectives in relation to problems emerging from that. And I think you have to pick the climate. I think you have to pick the time in order to go forward with something very positive like that. I think they can precipitate a groundswell of support, don't get me wrong. But I think right now we're in the fight of our lives for really important rights and laws that we have, and our resources are slim, and we need to focus on defence, I think, first and foremost, would be my personal advice.
Thank you, Attracta. No, I know the other panelists want to come in on that question of constitutionalising rights and increased protection.
I might just come in because you mentioned the report itself. So Attracta always exceptionally well on point. The report did find that it wouldn't be a panacea, that it would be a powerful tool, and that there's an untapped potential in the existing laws. So exactly, the political context is really key. And I think that's the missing piece, and you're very right to call that out. You need to have a supportive political environment to bring a referendum home successfully, and grassroots mobilization is essential. But really, there's a very long lead in time to getting grassroots mobilization through to changing the political dynamic, which is really the stage we're at, I think would be grassroots first, try to change the political context by reaching out to TDs, by reaching out to people with the power to change the narrative and telling them that this issue matters and why it's important, and making that case over probably maybe years before the time is right for a referendum. But as a legal accountability tool, it's very helpful. It's the fundamental law of the state. If you have a constitutional right, it adds great weight. But at the end of the day, it is only one piece of the puzzle, and the legislative framework has many, many others. And in the interim is the part, we are really in an emergency state in terms of the state of biodiversity in Ireland. We're certainly seeing the climate emergency unfold globally. So there's plenty that we need to do here and now, and certainly it's well worth having a very close read of the report. I think Georgina shared it in the chat, and have a good think about what the next steps are and how to get to where we want to be.
Thank you, Justine. I think we might wrap it up there. I'm conscious of not eating into people's lunches too much, but I just want to extend a huge thank you to all of our panelists. It was really amazing to hear all your perspectives and insights on the topic. Just to highlight again that if you want any more information about community law mediation, you can find it on our website and sign up to our newsletter as well. I also shared the links into the chat. The recording and materials will be shared over the coming days. And thank you all very much for attending. And again, thank you to our speakers. Thanks, everyone.
Yeah. Thank you very much, Georgina.